We are here in case 18 CR 1096, State of Ohio versus Charles Phelps. We are here for a hearing on a motion for expungement, sealing of record of conviction filed by the defendant, Mr. Phelps. The State of Ohio filed a response objecting to the motion. We are here, as I said, for a hearing. Mr. Phelps is here representing himself. The State of Ohio is present, represented by Assistant Prosecuting Attorney Adam Downing. So, Mr. Phelps, this is a hearing where you get an opportunity to present and say whatever you'd like me to know in consideration and in support of your motion. So, is there anything you'd like to say at this time?
Your Honor, I have temporary hearing loss in this ear.
Were you able to hear what I just said or not?
Yeah.
Well, you can try to use this. This will help you too.
I may not need it. So.
No.
That's all right, just gonna help you.
Testing. Is that an idea?
Is it adjusted it
Sure. I'll put them on if I need them.
Okay, I'll move up to the microphone a little closer. So what I was saying is that you have an opportunity at this hearing to say and state whatever you'd like me to know or consider in support of your motion. So is there, I've read what you have here, but is there anything you'd like to say at this time?
Yes.
Go ahead.
I'd like to, I had notes jotted down and everything, but I left them at home. But that's and the documents that you sent me. And that's the way of my God saying that I don't need it. I'd like to address all the issues in there. The first one I want to start with is nobody told me that I had to wait 10 years to get an expungement. I was told by Craig Berry after probation it would be 1 year. And I was never informed by my public defenders, the both of them, or my lawyers, or my expungement public defender. I have like bad memory thing going on here. Anyways, nobody ever told me that. You know, they just told me what I just said to you there, and I never would have pled guilty if that was the case, because that would turn into actually 2 years probation and waiting a year, because it said it went back to 2023, the first time that...
Let me stop you for 1 second if I can.
Yes.
Because you may not know this, maybe you do. There's a difference between sealing a record and expunging a record. That's actually two separate things. Sealing a record is that it's literally sealed up and nobody could see it.
Right.
It's there in like the clerk's office, but it can't be open, nobody's allowed to look at it.
Right.
Expunging is actually destroying it. But when it's sealed, it still has the significance of you can say that you've never been convicted of this offense. You don't have to report it if you're asked. You don't have to put it on applications. So you're eligible to have it sealed. You don't have to wait 10 years for that. It's the expunging that you have, it's the 10 years.
That's what...
And the law may have changed since you probably pled. Or was it always 10 years? I can't remember.
Interrupt, sir.
It's been 10 years
All right,
as long as I know. The difference between the sealing is just it can be accessed for certain very limited circumstances by the state or whoever.
Or law
I
enforcement.
don't mean to interrupt you, but like the NSA, the CIA, the FBI could get into that. You know, that's not completely sealed or whatever. My issue is with that coming up, and it has murder and homicide in there, which those charges were dropped. And that could escalate into something from overzealous people. Okay? That's what I'm afraid of. And as far as the issue...
Well, I'll let you finish. Go ahead.
Okay. No, go ahead.
There's two different... I can't grant something that you're not eligible for. Now, you're saying you weren't aware of it, fine, but then that's a different motion you want to file. If you want to try to vacate your guilty plea and go forward with trial, we can do that. I'm not saying I will grant it, but you can file that motion. But just because you claim you didn't know that and your lawyer didn't tell you that, and if you would have known that, you would have never pled guilty, doesn't give me the grounds to disregard the law and grant something that I don't have authority to grant.
Well, I understand that.
So if your argument is I would have never pled guilty if I would have known that and nobody ever told me that, or I was misled in that regard, then you would need to file a motion to try to withdraw your guilty plea and go forward with a trial, and I'll consider that. But that's not grounds to grant your motion to seal. You're eligible for sealing. It doesn't grant me the right to do an expungement.
As far as my getting, the rental situation and everything, there's really no proof I can give you of denial, because I went through this thing. Signature Health is where I went for my counselor. They hooked me up with a social worker that specialized in getting housing for people. A year and a half I was with her, and I got a second person, and they just dropped me after a while because anything I could get, I couldn't afford. I had filed for public housing. That took me 2 years. I got a package right before I went to West Virginia to live with my son. And I was to fill that out and possibly get the funding for that, and then it would proceed. But I read in there, it said, we don't even accept some misdemeanors, let alone felons. So that was a dead issue there. I would go and fill out stuff and it would get denied, but no one would ever tell me, no send me a thing saying, well, we've already written to someone. I didn't get anything like that. No phone calls, nothing. I mean, they don't care. They just want somebody to rent their place. And I started telling people on the phone that I have a felony. Well, right off the bat, they would say, I don't care, or, well, I don't accept that. So that, I want a fixed income. I can't be driving into another county. I don't have a lot of money. I had to borrow money to come up here. A lot of it was, and later I even went back to Signature Health, and I asked them to make a statement that I couldn't find housing because of my felony and everything. And her boss would not do it. It's a liability. I mean, as a senior, I could say I was discriminated against and file a lawsuit. I mean, you can sue over anything, but I don't want to do that. They helped me, I had other people who would say to me, I don't give a crap about your felony. You did your time. You went through the process, right? And then they would tell me, the wife tells me, $900, which I can't afford because I'm at $1,130 a month is all I get now. I mean, I had opportunities up here to make a little side money and stuff, doing odd things and stuff. But as far as the felony goes, it's not just the issue of housing. It's jobs. It's joining organizations. It's getting loans. I mean, even depending on what church you're in, you could get shunned out of a church, because you have a felony, because that's the way the world works. You know how people are. You're a judge. You've seen a lot, right? She says 900. He says 1,200. I'm going, well, which is it? And this is referred to a friend of mine that does work on their rental properties. And he said, well, there'll be an extra 300 because you're a felon. I'm like, that's $1,500. I get $1,130 a month. And I couldn't get the access to the public housing to help me with assistance at the time. But I went through this with a lot of people. Or the situations I got a really bad feeling about that were affordable. Now, I went through this ever since, what was it, July 20th, 2020. And I'm going through the same thing down there. I went to the library and got a list, because I don't have a computer, I don't get papers, nothing. There's nothing usually in the paper anyways, because it doesn't work anymore. They gave me a list of places to call. And I called them and everything, and I asked them, well, if you don't like, you don't want felons, and you've had problems with that because you did it before, and if somebody said they could rent to me, I couldn't afford it because I haven't got that stuff down there with assistance yet. Recently, my wallet was stolen. I've been having problems with IDs. I didn't have credit cards in my pocket to come down here. I just got my license duplicated and sent to me in the mail a couple of days before I came up here. Of course, I had that piece of paper, and I still have an Ohio driver's license. But anyways, no one would write me something saying they denied me because it's a liability. I was trying to prepare this for you of some kind of evidence because you said I have no evidence. And it's just always a dead end for me, you know. I mean, I've lived in my van when I had it. I've lived in a tent. I've squatted in abandoned buildings. I had friends that owned property and let me stay there. In most places, I had no utilities, heat or anything because they were all turned off, and I couldn't get them turned on because I didn't have the money for the fees and deposits in the one particular place I stayed. And when I was in Fairport too, I was having problems with the arresting officer who was always dogging me about something down there, you know. And I did my time. I did, you know, if you look at my record going all the way back, even when I was a juvenile, there's nothing there. I've never been adjudicated, arrested, anything like that. No drug dealing, nothing like that, you know, no rape, no murder, any of that kind of thing. Just the simple fact that those charges were dropped, but they're still on the docket, causes me problems. And that's all I can think of with that issue of that. Rehabilitation. I did everything I was expected to do. And I followed it to the letter. Because when I was in jail, there was all these young guys in there. Why they were in jail? Because they were violating their bond and probation, going back to dealing drugs or whatever they were doing. And I'm like, you got to be stupid to do that. I'm not going to do anything that jeopardizes myself to get through the process, you know, and move on. And the only issue I have is having the felony. It's caused me problems. I mean, it denies me my Second Amendment rights. I mean, you know, I don't have the right to protect myself. And, you know, it's like the Wild West in West Virginia. Everybody carries a gun down there and stuff. Not that I want to own a gun again because I sold everything I had, but I have the right to that. But I don't now. And, you know, I know even my first two public defenders even told me they had with Prosecutor Downing a conversation that he actually said to them, well, maybe it's not what it seems. Also, my lawyer's got a note that he wrote to himself about the guy that does the autopsy. He wrote a note to himself that he had commented to him that, well, on these other charges, you're going to have a real hard time proving this case. Now, when my lawyers got another pathologist who was a professor at Cincinnati, he was also the head of the Ohio pathology organization, and this guy usually charged $5,000 to $25,000 for this work. He read the stuff that was from the autopsy of the coroner, and he said, "I'll do this for $1,000." Well, why was that? I was actually verbally attacked in the hospital. I don't know if she was an expert or what. She was screaming at me that my mother had 100 hairline fractures stuff, a bone density thing. Well, a 95-year-old person gets that. And when you handle them, even in a nursing home, that occurs. But it turned out to be that she had a rare bone Vincent.
I'm going to interrupt you for 1 minute. We're not here to relitigate the case itself. You pled guilty to the charge that you pled guilty to.
Oh, I understand.
You were sentenced to that. We're not here to...
Well, that was only because I got bad advice from my lawyers.
Well, then, again, that's not what this is about. If you're contesting the original case itself, then you would need to file a motion to withdraw your guilty plea, and if I granted it, we would go to trial. We're not here to talk about the original case and whether you're guilty or not guilty or anything like that at this point. This has nothing to do with that.
Well, I did fail my mother. I mean,
Well, you
failed.
pled guilty to the charge, and you're...
Yes, I did.
So that's resolved. That's over with. We're not here to talk about the whether you're guilty or not guilty or any of that kind of stuff. If that's the issue you want to raise, then it's a different motion you have to file. If you think you were misled or given wrong information, then that's a motion to withdraw your guilty plea that you could file, and I would consider that. And if I granted it, then I'd set it for trial.
All I'm asking, Your Honor, is...
I mean, the arguments you had been making were legitimate arguments. Well, how is this impacting you and everything? But now you're moving back into the facts of the case.
I just want to go on and be able to function as a normal citizen. You know, I just want to go on. I want this to end. I want to stop coming here, you know, before you and having you say, you know, I knew you wouldn't do it, but this guy again, you know? I want my life back.
All right. Well, thank you, Mr. Phelps. Mr. Downey for the state of Ohio.
Thank you, Your Honor. The court did receive the amended state's response. Is that right?
Yes.
There wasn't a whole lot that the defendant stated in his filing this time around as far as any specific reasons. I did anticipate that coming in today that, as it seems to be the case, that he would have some additional information that wasn't provided in the motion. I guess I just would, as it stands now, just based on what he said, there's not a whole lot of specifics from, he mentioned, for example, the job denial and the organization denial and church denial and loan denial, but it was unclear to me any specifics as to, you know, how many or when did he attempt to gain access to these organizations or churches or loans, and that he was denied those.
Can I answer?
No, you had a chance to speak. He's going to speak. I'll let you have one last time after he's done to speak. I don't want to interrupt each other.
And if he does have those specifics, then that I think would change the calculus a little bit. But just based on what we've heard today and what was in the motion, I do believe that the state does still have a vested interest in maintaining this conviction, you know, because it was a serious charge. It's a felony. You know, this charge on its base is a misdemeanor. The reason it was a felony in this case was because of the serious physical harm suffered by the victim in this case, and I don't think that can be ignored. I think that's significant, and it's why the state ultimately pursued the case. And you know, it is a balancing act here, and I still think that interest is outweighed here on the state side. Of course, that, you know, subject to change on that balancing if there's any other specifics. And I have nothing else to really say other than what was already filed in the motion.
Mr. Phelps, did you want to be heard one last time?
Just like in the document you sent me issuing, or the issue of me being a caregiver again, that'll never happen after what I know now. And everybody in my family is deceased. My health is getting to the point where I'm going to need.
How old are you now?
72.
I know I have that. 72. Okay.
I have congestive heart failure, cardiovascular disease, diabetes. I have terrible arthritis in my hands. The notes I read, I don't even know if I could have read it back to you, is what I put down about dates and stuff. But it's like the only people I have is my son and my granddaughter, my daughter and his husband, and I'm expecting another grandchild. And everybody else is dead and gone. They're all gone. All I have is nieces, nephews, and cousins. Some of them I haven't seen for 30, 40 years. And I don't consider them family anymore because They barely ever made contact with my mother when she was alive. But that's, to me, I would never even think about taking on the thing of a stranger as a caregiver. You know, becoming an executor of a friend's estate or something. I would not do that at all, period. And as far as the issue of what happened with her injuries and everything else, there was no malice or intent to that. If this would have went to trial, a lot of things would have come out that, you know, you're not aware now. And I still would have got the failure to provide charge. I still would have been convicted of that. You know, I mean, I figured, yeah, absolutely. I made some mistakes, absolutely. But I did the best I could do under the circumstances. I never appointed myself the sole caregiver, okay? My brother never helped. All he did was come and get money from my mother. His wife is the same. My stepniece was the same. At one point, my mother didn't even want her granddaughter even coming to the house, okay? And at one point, things got real out of control with him. He still had a key to the house. And I says, she wants here for help. She wants you to help to make it easier on me. Well, he made a statement when I'm on at one time. He says, well, David lives with you now. You bought him a house. And, you know, it's up to him to take care of you. You know, in other words, he didn't want nothing to do with it. But he still wanted her money. He always said, borrow, borrow, borrow. I watched this for decades, even when my father was alive. They never got a dime back. And he was going in the house and writing checks and taking cash out of there. And she had told him that no more money, Robert. No more money anymore, because...
All right, sir, I don't know what this has to do with your motion for an expungement. You're talking about your brother and taking money from your... We're here to try to...
All right, I dropped that. So, actually what you're telling me is for me to file for a seal.
You did file for... You filed for both, so I can consider the sealing. You filed for sealing / expungement, so you filed for both. What the state was arguing, and they're accurate, is that you are eligible to have your record sealed. You're not eligible to have it expunged.
Okay.
So if it's sealed, you're still allowed to say, I've never been convicted of anything. You don't have to report it on applications or anything like that. Somebody can't just look it up on the clerk's office.
Yeah, it won't come up on the docket.
Right. That's what a sealing would be, and that's what you're eligible for. So that's what I will be considering. That's what I will consider.
So I don't have to refile?
No. What you filed is sufficient to request that.
Well, I'm fine with the sealing.
Okay.
That was my...
I know this is just a form that you were given.
That was the public defender in 23 that when she wanted to go fully for the expungement. I didn't even realize that the seal was available in that.
So I'm going to consider a motion to seal. You don't have to refile it. That's before me. I'm going to take all these arguments under advisement, and then I'm going to issue my ruling very shortly.
Thank you, sir.
Do we have an address for you? The Madison, West Virginia address?
Yeah, it's 751 Orchard Drive, Madison, West Virginia.
Right. That's where we'll...
25130.
And there's no email though, correct?
No, I don't have anything.
All right. Then we will I'll send my entry to that address.
Thank you, Your Honor.
All right, thank you.
All rise.
Here in the matter of the State of Ohio versus Timothy L. Davis, this is case 21 CR 925. Mr. Davis is present in court. He's accompanied by his attorney, Mr. Corey Hinton. He was last before the court and he entered a plea of guilty to failure to appear, a felony of the third degree. Pre-sentence investigation report was ordered and we are here today for sentencing.
Mr. Hinton, any reason not to go forward with sentencing?
No such reason, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor. As you know, in this particular situation, the underlying offenses filed against Mr. Davis were eventually dismissed. However, there was the instant case which had to do with a missed court hearing. I know Mr. Davis regrets missing that hearing. I know that this round of action, he's been in touch with me on a very regular basis, has been to all the hearings, has been early to all the hearings. I would ask that the court consider community control sanctions without any residential sanctions. You know that Mr. Davis has a lot of medical issues. He's not working, but he's keeping himself busy with schooling, resides in Cuyahoga County. So I'd ask the court to sentence Mr. Davis to probation and to structure it in a way that will accommodate him, but also accomplish the purpose that the court needs to accomplish for purposes of community control. Thank you.
Mr. Davis, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say?
No, sir.
Mr. Hinton, anything else?
Nothing further, Your Honor.
Ms. Milligan for the state.
Your Honor, this presents quite a puzzle here because to believe the defendant, there's no sanction possible that wouldn't impose a great burden on the community resources or to him. The problem there is you have to believe him. And we do know that he is on dialysis because of his prior jail stay. But even to the facts underlying his failure to appear itself, we have no resource other than his claim that he was hospitalized and unable to come. We've seen no verification of any of these troubles. We do know that he is on dialysis. We also do know from the PSR that he smokes marijuana. So he has a drug problem that this court would always address with any other defendant. But alas, we can't drug test him. But we don't know the particulars of that. So the court is left in a position with very little information and very little to work with here. But there should be a sanction, perhaps a jail sanction. We believe that to the extent that a conviction still is stigma in this community or in this society, that he should be convicted and the world should know that he does not appear when he's supposed to appear. I wish we knew more.
Thank you. This court reviewed the pre-sentence report and investigation and considered the facts and circumstances of the offense involved with this case, the nature of that offense, and considered what's been said here by Mr. Hinton and the prosecutor. The defendant was afforded an opportunity to address the court, chose not to make a statement. All this is considered in light of the purposes and principles of felony sentencing set forth in 292911. As for the factors in 292912, the court notes that the defendant was gone for 4 years. That makes it more serious than the normal failure to appear. He claims that he was in the hospital that day. There's no proof to support that, but regardless of that, you were gone for 4 years. You claim that you didn't know about it. Well, I don't know why you would think these charges just would up and disappear. They don't just go away without a court hearing coming forward. That's what you want us to believe that you think happened, and that doesn't make any sense. You knew about it, you didn't show up, and you just were hoping it was going to go away, and it did in terms of the drug charges, and you got lucky there. But you're gone for 4 years, and provided there was no phone calls, you didn't let us know. No one called and said, hey, I'm in the hospital, I have some issues. Nobody called on your behalf. Years went by. That's not the way it works, and it makes it more serious. Nothing makes it less serious. As for recidivism factors, the court finds the defendant, there is a history of criminal convictions, nothing, well, that's not true. Attempted felonious assault, defendant did go to prison back in 2012. So there's a prior felony as well, prior prison sentence. There's no genuine remorse. Doesn't think he did anything wrong. Just thinks I should give him a pass. I don't think anything should happen to him. I should just ignore this. I should write you a letter of apologies for making you come in here on your own. You don't think anything should happen? Not, you want to speak now?
Your Honor, in my defense, I was in the hospital on November 4th, 2021.
Okay, where were you in 2022, in 2023, in 2024?
I was in and out of the hospitals, Your Honor,
Okay.
due to having fluid overloads.
Is there anything else you want to say? I gave you a chance and you said you didn't want to say anything. Now you want to say something.
No, sir.
Again, there's no genuine remorse from the defendant at all. He doesn't think anything should happen to him. He should just get a pass from the judge. He makes all these claims of stuff, and there's no supporting documentation. I gave him chances for that. I gave him chances to provide documentation, get records for the jail stays, for the supposed not being able to provide urine samples, and I haven't been provided anything. As for factors indicating recidivism is less likely, nothing stands out. The 2913B1, the court finds the defendant previously served a prison term. Again, that overrides the presumption for probation, permits the court to impose a prison sentence without having to make any findings for that. I don't know how amenable the defendant is to community control sanctions. Obviously, a large part of that is the physical condition, and that's not being held against the defendant. But in terms of the defendant's attitude, he's not very amenable. Again, doesn't think anything should happen to him. Just thinks he should be given a pass on this. Nothing should happen. And when he has reported to probation, again, he thinks he should get special treatment. He apparently thinks you should be allowed to smoke marijuana. Nobody else does on bond. Nobody else does on probation, but apparently you should be able to do that. Everybody's got to get urine screens. I've asked for documentation saying you can't do that. We haven't been provided anything. And if that was the case, I should be able to have a doctor send me something saying you can't do that. And we give you that chance. I don't have that.
I just want to, the court does have a correspondence that I've sent over, just may not have had
It doesn't say
the
that.
exact information.
I did get something. I won't say it was completely ignored. I did get something, but it doesn't say that. The defendant says that, but no doctor says that. I will find at this time, however, that the defendant in prison would not be consistent with the purposes and principles of sentencing. And the defendant would be amenable to community control sanctions. So I'm going to place the defendant on community control sanctions for a period of 12 months. I am going to order, there's going to be consequences. I'm going to order the defendant serve 22 days in jail. He has credit for 12 days he serves. So there's 10 days in jail that you're going to serve. That's going to begin on November 16th at noon. So next Sunday, this coming Sunday, you're to report to the jail at 12 o'clock. You'll be brought to your dialysis appointments on Tuesday, Thursday, and Saturday. You'll be released on Wednesday, November 26th at noon. So you need to report by noon next Sunday. If you don't do that, there'll be a warrant out for you, and then you're gonna sit in jail. They'll come get you, and you're gonna sit in jail over the holidays. So again, report next Wednesday, this coming Sunday, a week from yesterday, at 12 o'clock. Further conditions, you're not to use any drugs or alcohol, you're not to use marijuana, and unless I get something from a doctor saying you can't provide a urine sample, you're going to provide your random urine screens when requested. If you don't, you'll be violating your probation. So if you can't do that, I need something telling me I can't do that.
You gotta get one that's more specific, because that one doesn't say it.
You don't dictate how everything works, Mr. Davis. That's how you've been
never
operating
trying
this
to.
those things so far. But you come across as thinking you're very entitled, and that's not the way this works. So no drugs or alcohol, random urine screens when requested, unless they'll get medical documentation saying that's not possible. You're still not to use any drugs or alcohol. I'm going to order that he do monthly reporting to the Lake County Probation Department. So once a month, you're going to report to the Probation Department. To continue with your education. Pay your court costs and supervision fees. Jennifer, anything else I should consider?
No, Your Honor, thank you.
Mr. Davis, you understand the conditions of your probation?
Yes.
Any questions for me?
No, sir.
I need to advise you, if you fail to comply with these conditions or any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another crime, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it would be 18 months in prison. So that's what's hanging over your head. You understand that?
Yes, sir.
All right.
But I would like to also note that I did send paperwork stating about me not being able to produce urine from my kidney doctor.
Well, then I need someone give it to me, because I don't have that.
I brought it to my PO the last time I was here. I believe she scanned it off to you.
Your Honor, it's the same letter that you've seen. It does not.
It doesn't say that.
It does not
So
indicate that you cannot produce urine.
it doesn't say that. So I got the letter that you provided to her, and she gave it immediately to me. It doesn't say what you say it says.
So you needed to actually say I don't produce urine.
Well,
That,
yes.
okay,
Right.
no problem.
Or, it doesn't have to. If you can use medical terminology if this means the same thing, but that is not what I got. It doesn't have to. I'm not saying these are the exact words. You can do it in whatever medical terminology he wants to, but that has to be what it means, and that's not what we got. We didn't get that. Small, got anything else?
No, Your Honor, thank you.
Mr. Hinton.
Your Honor, nothing further other than a bond being released.
I will release bond because the order of for the jail is sentence is a condition of probation. So if he doesn't do it, then he's violating his probation.
Okay.
So
Thank you.
bond will be released.
here today in the state of Ohio versus John Callahan, case number 25CR1021. The defendant is present with counsel Corey Hinton, and we're here today for a sentencing hearing. We were last before you on October 2nd for an information hearing where the defendant pled guilty to count 1, possession of cocaine, a felony of the 5th degree with a forfeiture specification. During that hearing, a pre-sentence report and drug and alcohol evaluation were ordered. Those have since been completed, and the defendant has 11 days of jail time credit. Thank you.
Mr. Hinton, any reason not to go forward with sentencing?
No such reason, Your Honor.
Anything you want to say at this time on behalf of your client?
Your Honor, I would like to say some things on behalf of Mr. Callahan. I've known him for a long time, and I know that he's had long periods of sobriety. So even though he's been in a lot of different treatment facilities, I know that it does work to some extent in that, again, there are these long periods of sobriety. I know he has a great attitude about being sober and a great attitude about treatment. As a result of that, Your Honor, I would be asking that the court order him to community control sanctions. I think that that would be appropriate. I think he would be amenable, and I think that he'll be successful. Thank you, Your Honor.
Thank you. Mr. Callahan, you have the right to address the court before you are sentenced, and you can say anything that you would like. Is there anything you want to say at this time?
Yes, Your Honor. I've been thinking about this for a long time, and I just don't know. Over the years, I've just been in and out of mental health places and drug places. This last one, I was going through a lot of medication switches, which led me into kind of a bad place mentally. I take full responsibility for that. Since that time, I've maintained my full-time job. I was in school full-time, going for my Human and Social Services degree and associates. I'm maintaining that and starting that again in January to complete that. I have a full-time job right now, making good money. I'm in good standing with them. I'm pretty much a full-time father to 2 beautiful babies, and I got actually one on the way, we just found out. You know, it's just one of those things where, you know, I do fall down, but I always pick myself back up, and I do always put the shine back on me, and I do push forward. I keep God in front of me. My family is everything to me, and you know, I jeopardize my freedom here, and I do take accountability to that, and I do apologize for that, and that's all, Your Honor.
Thank you. Mr. Hinton, anything else?
Nothing further, Your Honor. Well, I guess I would indicate that I know in between the time that this incident happened and then the case making its way over here, he did voluntarily complete quite a bit of treatment, and then again he turned himself in
I have treatment right now
on this case.
I'm in mental health services right now.
And he indicates he's actively in mental health services as well. So I bring that up so that the court knows that he's not just sitting around waiting for the court to order him to treatment. He is proactive in that regard.
Well, what you're saying, he's doing something now with treatment?
Mm-hmm. Yeah, I'm in mental health services with Signature Health.
Mental health services. Right.
Yes, I actually have an appointment on Thursday with my counselor and a psychiatrist. And I was actually also going to sign up for ILP classes just to kind of get myself together to fill in the time.
One second, please. Ms. Bell, on behalf of the state of Ohio.
Thank you, Your Honor. The state had the opportunity to review the pre-sentence report in this case, and this is a borderline case. Unfortunately, there's just too much in the defendant's history and past to overlook here. The defendant has a history of criminal conviction. He has a prior prison that was stemming from a 2019 case, but I believe he got out of prison in 2022. The defendant has also had the opportunity for treatment, by my count, 9 times. There's been a few PVs also in his past. The state cannot say that he'd be a good candidate for community control and would recommend prison. Thank you.
Thank you. Court reviewed the pre-sentence report investigation, drug and alcohol evaluation. I've considered the facts and circumstances of the offense involved, the nature of the offense involved. I've considered what's been said here in court today by Mr. Hinton, the defendant himself, the prosecutor, the recommendations. All of this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, nothing stands out factually indicating it's more or less serious. As for recidivism factors, we find several of these are present, indicating recidivism is more likely. The defendant has a history of juvenile delinquency adjudications as well as convictions as an adult. Goes back 18 years. Defendant has previously served a prison term before. He has been on probation before in the past and has violated his probation, so he has failed to comply with previously imposed sanctions ordered by courts. That's a factor indicating recidivism is more likely under the statute. Last time in court, he was given a break. He had a felony charge reduced to a misdemeanor, and he successfully completed probation. But then, within a few months after probation, 6 months, you committed this offense. Certainly a drug abuse problem that relates to the offense. I can't say a defendant doesn't recognize it or refuse treatment, but here we are again. He violated the conditions of his bond in using marijuana. And he wants to be able to continue using marijuana. Your problems all started in juvenile court 18 years ago because of marijuana. No factors indicate recidivism is less likely. Under 2913B1, court notes defendant has previously served a prison term that overrides the presumption for probation, permits the court to impose a prison sentence without having to make any findings. The defendant's history, prison certainly is consistent with the purposes and principles of sentencing. But I will make a finding at this time the defendant is amenable to a community control sanction. I'll give you a chance, Mr. Callahan, but this isn't going to continue on with the violation and continuing on more treatment and another violation. You're getting a chance here. You need to take advantage of it. I'm going to put you on community control sanctions for a period of 2 years. I'm going to order that you serve 60 days in jail. You have credit for 11. I'm going to order that as soon as a bed is available at Concord Pines or Lake House, that you be released from the jail to enter that facility and successfully complete the program there. Any remaining jail time will be vacated. You won't have to come back and do that. You'll successfully complete the treatment program at either of those, whichever facility you get into there first. Follow all their aftercare recommendations. Further conditions, you're not to use any drugs or alcohol. That includes no marijuana. You submit random urine screens. They must be negative. A positive screen is a violation. You're to attend 3 AA meetings a week and have an AA sponsor or NA. To obtain and maintain full-time employment and or education or some combination of the two that keeps yourself busy on a full-time basis. To continue with mental health services, follow their recommendations, take all medications as prescribed. You're only to have one doctor and one dentist that could prescribe you medication. If you have a specialist, that's fine too, but probation needs to know who the doctors are that you're getting your prescriptions from. Can't get them from anyone else. You get to fill them at one pharmacy. They need to know where that is. You need to sign whatever releases that they need so they can speak with doctors or counselors if necessary. You pay court costs and supervision fees. I'm going to order the forfeiture of the contraband or instrumentalities in the specification. Ms. Bell, who were the two individuals that were there? I know one was Adam Weiss. Who was the other? It was a woman, female.
One moment, Your Honor.
At least the references of female. I don't know if you have a name or not.
And we don't know the identity of that female, Your Honor, as far as Mr. Callahan off the top of his head.
There's a female listed in the report as an Erin Callahan.
It's my mom, Erin. Kathleen Erin.
There might have been contact with his mom after the fact.
What's your mother's name?
Kathleen Erin Callahan.
Kathleen Aaron?
Callahan, yes.
So she goes by Aaron?
No, she was by Katie.
That female's name is not in the
Sorry?
report. The female's name is not in the report.
All right. Well, you have no contact with Adam Weiss, W-E-I-S-S. Who is he to you?
Just an acquaintance, nobody really.
Well, no contact with him. Stanley, anything else I should be considering here?
Oh, no, Your Honor, thank you.
So, Mr. Callahan, you understand the conditions of your probation?
Yes, Your Honor.
Any questions for me?
No, Your Honor. Thank you.
I need to advise you, if you fail to comply with any of these conditions or any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another offense going forward, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. Certainly that's most likely what will happen, and that would be 12 months in prison. So that's what's hanging over your head. You understand that?
Yes, Your Honor.
All right. I will, well, there was no bond that was posted, but you can release bond in the entry. Anything else, Ms. Bell, for the state?
Nothing further, Your Honor. Thank you.
Mr. Hinton?
Nothing further,
All right,
Your
thank
Honor.
you. Mulligan.
Your Honor, we're here in the matter of the State of Ohio versus Michael F. Smith. This is case 25 CR 526. Mr. Smith is present in court. He's accompanied by his attorney, Mr. Corey Hinton. He was last before the court where he entered a plea of guilty to a felony for failure to comply with an order or signal of a police officer. At the time of the plea, the court ordered a pre-sentence investigation report. That having been accomplished, we're here today for sentencing.
Thank you. Mr. Hinton, any reason not to go forward with sentencing?
No such reason, Your Honor.
Anything you'd like to say on behalf of your client?
Your Honor, I would like to make comments on behalf of my client. I would indicate that in this particular situation, we are seeking community control sanctions. I do think that Mr. Smith would be an ideal candidate for community control. It appears that there's been a gap between now and the last time that he had a conviction. It doesn't appear that he's had a prior prison sentence. I know that Mr. Smith has cooperated with the pre-sentence report. He's abided by his conditions of bond. Specifically, he tested negative for all drugs during his screening process with the probation department. I know that Mr. Smith is employed. It's outlined in his pre-sentence report. He's self-employed, but he works in the music industry. He has a studio. He also indicated that he recently inquired into picking up some additional work around the holidays, delivering packages. It's a place out of Avon, and he's been in touch with an individual there. As a result of those reasons, Your Honor, I would ask that the court impose community control sanctions. I think that the biggest punishment in a case of this nature comes in the way of the license suspension, especially in a situation like this where there's a prior, so that in itself is a very large punishment. And I would ask for no additional jail time, so no additional residential sanctions, but I know Mr. Smith does or should be entitled to credit for a handful of days that he completed in the jail prior to posting bond. Thank you, Your Honor.
So prior to coming out here, we said there's no reason to not go forward with sentencing. You had a chance to discuss the license suspension issue with your client?
I did, Your Honor. I pulled up the pre-sentence report so that I could go over the exact details and dates of the prior convictions.
Thank you. Mr. Smith, you have the right to address the court before your sentence. You can say anything you like. Is there anything you want to say?
Yeah, I just wanted to say that I deeply apologize for this situation. I made a wrong decision. I know moving forward I'll make better decisions. And I just apologize and accept any consequences that happens. I just want to thank my lawyer for helping me with this situation.
Thank you. Mr. Hinton, anything else?
Nothing further, Your Honor.
Ms. Mulligan for the State of Ohio.
The state would recommend community control under the terms and conditions the court deems appropriate.
Thank you. Court has reviewed the pre-sentence report and investigation. Consider the facts and circumstances of the offense involved and nature of the offense involved. I've considered what's been said here in court today by Mr. Hinton, the defendant himself, the prosecutor, the recommendations from each side. All this is considered by this court in light of the purposes and principles of felony sentencing set forth in 29-29-11. As for the factors in 29-29-12, Nothing indicates the offense is more serious in regards to the factors in 29-29-12. However, the court is also required to consider the factors specifically set forth in 29-21.331 for this type of offense, which deals with the manner of the defendant's driving. In this regard, the court notes that the defendant was traveling over 80 miles an hour in a 25-mile-an-hour zone. That makes it well more serious than normal. He also at least went through 2 stop signs observed by the officer, which is factor listed there. That makes it more serious as well. This conduct created a significant risk of physical harm to other motorists, pedestrians. No factors indicate it's less serious. As for recidivism factors, the court finds the defendant does have not only a history of criminal convictions, but a history of failing to comply with orders or signals of police officers. This is the second conviction for that specific offense, but he also has a prior conviction for an attempted failure to comply, which he received obviously a break on last time he was in court, because they reduced it to that. So this is the third time now that you've done this, fleeing police. You say it's because you have bad run-ins with police officers. Look at your traffic record, shows me it's because you drive without a license and you know it, and you're going to get in trouble if you get stopped. You've got a history of driving under suspension for the last 15 years. 1, 2, 3, 4, 5. 1, 2, 3, 4, 5, 6, 7, 8, 9. 9 convictions for either driving under suspension or not having a driver's license. So I don't really know if the license suspension that you indicate here is the worst thing, if it's really a punishment for him, because it doesn't matter to him anyway. He's been driving for the last 14 years without a license. Doesn't comply with orders of courts. That's a factor indicating recidivism is more likely. As previously strike that. No factors indicate recidivism is less likely. Under 29, 13B1. I don't find any factors. I will find at this time, despite this being the third time that he's gotten in trouble for this type of conduct, that prison is not consistent with the purposes and principles of sentencing, and he is amenable to community control sanctions. So I will place the defendant on community control sanctions for a period of 2 years. I am going to order that the defendant serve 60 days in jail. He has credit for 3 days he's already served. I'm going to order that when he's in jail that he enter and complete the decision points program, successfully complete that program, follow whatever recommendations are part of that program. Further conditions, the defendant is not to use any drugs or alcohol. That includes no marijuana. You submit random urine screens. They must be negative. Positive screens a violation. You can't tamper with the urine sample, bring in fake urine, someone else's urine. That's even worse than testing positive in my book. When you get out of jail, I want you to get a drug and alcohol evaluation. Follow whatever recommendations are made, if any, for any type of counseling, treatment, AA, whatever they recommend will be a condition of your probation. You're to obtain and maintain full-time employment. Mandatory license suspension is, Class 1 suspension is required, and I will impose a Class 1 suspension, which is a lifetime license suspension. Defendant's order to pay all costs and supervision fees. Specific conditions, aside from the driver's suspensions, you're not to drive a motor vehicle. I want that as a condition of probation. So it doesn't require necessarily a conviction for DUS or being stopped by police. If you're driving a vehicle, you're violating your probation. Mr. Tompkins, is there anything else I should consider here that you want me to?
I don't believe so, Your Honor.
Mr. Smith, do you understand the conditions of your probation?
Yes.
Do you have any questions for me?
No.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another crime while you're on probation, a motion to terminate your community control sanctions will be filed. And if it's found that you violated, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. And if I did that, it would be 18 months in prison. And that would be consecutive to any other sentence you're serving at that time or that you may be getting sentenced to at that time. It must be consecutive as well. I will release the defendant's bond at this time, too. Ms. Mulligan, is there anything else for the record?
No, Your Honor, thank you.
Mr. Hinton.
Your Honor, in speaking with Mr. Smith, he is requesting a very short stay of the sentence just so that he could get a few affairs in order. I'd have no reason to think he wouldn't report.
No, he's had 5 weeks to get his affairs in order. He knew the sentencing was on this day from October 2nd. So that request is denied. Thank you.
All rise.